anything said by a lawyer is not evidence. That doesn't mean to imply that it's unimportant. In their opening statements, the lawyers will let you know what they believe the case to be about. Maybe a good time for you to take notes because you will not be able to get readback of that opening statement. After the opening statements are given and after I've read these instructions, we're going to take just a brief recess and then we'll come back in and then begin the evidence portion of the trial. Jury service is very important, and I would like to welcome you and thank you for your service. Before we begin, I'm going to describe for you how the trial will be conducted and explain what you, the lawyers, and I will be doing. When I refer to the people, I mean the attorney from the district attorney's office that are trying the case on behalf of the people of the state of California. When I refer to defense counsel, I mean the attorneys who are representing the defendant, Mr. Martin, in this case. The trial will proceed as follows. The people will present an opening statement. The defense may also wish to provide an opening statement. The purpose of an opening statement is to give all of you an overview of what the attorneys expect the evidence will show. Next, the people will offer their evidence. Evidence usually includes witnesses' testimony and exhibits. After the people present their evidence, the defense may also present evidence, but is not required to do so. Because the defendant is presumed to be innocent, he does not have to prove that he is not guilty. After you've heard all the evidence and before the attorneys give their final arguments, I will instruct you on the law that applies in the case. After you've heard the arguments and instructions, you will go to the jury room to deliberate. I will now explain some basic rules of law and procedure. These rules will ensure that both sides will receive a fair trial. During the trial, do not talk about the case or about any of the people or any subject involved in the case with anyone, not your family, friends, spiritual advisors, or therapists. Do not share information about this case in writing, by email, or on the internet, or any other social media. You must not talk about these things with the other jurors either until the time comes for you to begin with your deliberations. As jurors, you may discuss the case together only after all the evidence has been presented, the attorneys have completed their arguments, and I've instructed you on the law. After I tell you to begin your deliberations, you may discuss the case only in the jury room and only when all 12 jurors are present. You must not allow anything that happens outside the courtroom to affect your decision. During the trial, do not read, listen to, or watch any news report or commentary about this case from any news source. Do not do any research on your own or as a group. Do not use a dictionary, the internet, or any other reference materials. Do not investigate the facts or the law. Do not conduct any tests or experiments or visit the scene of any event involved in the case. If you happen to pass by the scene, do not stop to investigate. During the trial, do not speak to any party, witness, or lawyer involved in the trial. Do not listen to anyone who tries to talk to you about the case or about any of the people or subjects involved in it. If someone asks you about the case, you must tell him or her that you cannot discuss it. If that person keeps talking to you about the case, you must end the conversation. When the trial has ended and after you've been released as jurors, you may discuss the case with anyone. But under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about this case. If you do receive any information about this case from any source outside the trial, even unintentionally, do not share that information with any other juror. If you do receive such information, or if anyone tries to influence you or any juror, you must immediately tell the deputy. Some words or phrases that may be used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary everyday meanings. Keep an open mind throughout the trial. Do not make up your mind or about the verdict or any issue until after you've discussed the case with the other jurors during your deliberations. Do not take anything I say or do during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. Do not let bias, sympathy, prejudice, or public opinion influence your decision. You must reach your verdict without any consideration of punishment. You have been given notebooks and may take notes during the trial. Do not remove your notebooks from this courtroom. You may take your notes into the jury room with you during your deliberations. I do not mean to discourage you from taking notes, but here are some points to consider if you do take notes. Note-taking may tend to distract you. It may affect your ability to listen carefully to all of the testimony and to watch the witnesses as they testify. And the notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. You must decide what the facts are in this case. You must use only the evidence that is presented in this courtroom. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else that I tell you to consider as evidence. The fact that the defendant was arrested, charged with a crime, or brought to trial is no evidence of his guilt. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys will discuss the case. Their remarks are not evidence. Their questions will not be evidence. Only the witness's answers are evidence. The attorney's questions are significant only if it helps you to understand the witness's answers. Do not assume that something is true just because one of the attorneys may ask a question and suggest it is true. During the trial, the attorneys may object to questions asked of a witness. I will rule on the objections according to the law. If I sustain an objection, the witness will not be permitted to answer, and you must ignore the question. If the witness does not answer, do not guess what the answer might have been or why I ruled as I did. If I order testimony stricken from the record, you must disregard it and not consider that testimony for any purpose. You must disregard anything you see or hear when the court is not in session, even if it is done or said by one of the parties or witnesses. The court reporter is making a record of everything that is said during the trial. If you decide that it is necessary, you may ask that the court reporter's record be read to you. You must accept the court reporter's record as accurate. You alone must judge the credibility or believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudice you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are: how well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all of the other evidence in the case? Did other evidence prove or disprove any fact about which the witness testified? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If you do not believe a witness's testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. If you decide that a witness deliberately lies about something significant in this case, you should consider not believing anything that witness says. Or, if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. That, ladies and gentlemen, are the initial instructions. You'll receive additional instructions in law as we go through the trial. So at this time, I'm going to turn the floor over to the lawyers for opening statement or statements. And once again, remember, this is not evidence. You will not get readback of it. And so if you wish to take notes about what this case is about, you may wish to do that now.